Welcome to the deep dive. Today we're zeroing in on a really specific part of patent law. It's something that could genuinely be a game changer, especially if you, the inventor, have already started sharing your ideas.
Absolutely. We're diving into the MPEP, the Manual of Patent Examining Procedure, Chapter 2100, specifically Section 2153.
Right, MPP Section 2153, focusing on patentability.
And for you, our listener, maybe think of yourself as the learner here. This section is vital. It's about the exceptions, the carve-outs to the rules about prior art.
Prior art being the stuff already out there that can stop your patent.
Exactly. But these exceptions, under the American Invents Act, the AIA, create grace periods. They protect your own early disclosures.
Which seems only fair, right? If I put it out there, why should it block my patent? So the AIA addresses that.
It does. These rules, 35 U.S.C. 102b1a and b, they act as a sort of buffer. They can stop your own publications, presentations, things like that.
As you did.
Or things done by someone who got the information from you from being used against your patent application later on. It's huge if you've presented at a conference, published early,
Yeah, because inventors need to talk about their work, get feedback, maybe find funding. Okay, let's break down the first part. MPEP, Section 2153.01. This is about the inventor's own disclosures within a one-year window.
That's the core idea, yeah. It comes from 35 U.S.C. 102b1a. Basically, if you or a co-inventor or someone who learned it from you disclosed the invention.
Publicly disclosed it.
Right, publicly. And that disclosure happened no more than 1 year before your effective filing date. Then that disclosure isn't treated as prior art against you under 102A1.
Okay, so that year leading up to filing is crucial. My own sharing doesn't automatically torpedo my chances. But you mentioned attribution earlier. Why is making sure it's clearly my disclosure so important?
That's key. The MPP is really clear on this. It has to be traceable back to the inventor or someone who got it from them. You can't just point to some random article and say, that was me.
Prevents gaming the system.
Exactly. So the classic example is a paper where you're listed as the sole author. If that paper was published within the 1-year window before you filed, that's a strong case for the exception.
Okay, makes sense. Let's try a scenario. Say I present my cool new gadget at a trade show in June. Then I file my patent application the next May. That June presentation shouldn't count against me, assuming I was the presenter, of course.
Generally, yes, that's how it should work. It gives you that breathing room. Think about academics, startups, they often need to publish or present early. This protects them.
It allows for that necessary communication without immediate patent death.
Good. Now, the MPEP points to 37 CFR 1.130. What's that about?
Right. So if an examiner does cite your own earlier work against you, maybe they found that June presentation, you'll likely need to file a declaration. That's under 37 CFR 1.130. It's basically your formal statement to the USPTO saying, hey, that disclosure you found, that was mine or derived from me, and it's within the grace period.
So I have to actively claim the exception if it gets challenged. It's not automatic. Correct. You need to provide evidence, connect the dots for the examiner.
And I remember the MPEP suggested maybe putting information about prior disclosures into the patent application itself.
Yes, that could be a really smart move. If you mention relevant presentations or papers in your application specification, it gives the examiner context up front. It can head off those kinds of rejections before they even happen. Makes prosecution smoother.
Like anticipating the issue. Okay. That covers my own disclosures. But what about other people? What if someone else talks about my invention after I've already disclosed it? That's where MPP Section 2153.02 comes in.
Exactly. And 35 U.S.C. 102b1b, this is the second shield in the grace period. It protects you if, after you've publicly disclosed something, a third party then discloses the same subject matter.
Okay, walk me through that. How does that work?
Well, the MPEP uses an example like this. You disclose your invention on, say, January 1st. Then maybe someone who saw your disclosure, a third party, writes about it or republishes it on March 1st. Under this rule, that March 1st disclosure by the third party can't be used as prior art against you because you had already disclosed that subject matter earlier.
I see. So it stops someone else from essentially echoing my disclosure and having that echo count against me. That seems fair.
It is. But there's a really critical catch here.
Oh, what's that?
The subject matter disclosed by the third party must be the same as what you disclosed. The MPEP uses terms like identical or substantially the same.
So it has to be pretty much the same stuff. It's not like if I disclose concept A and someone else later discloses concept A plus B, that their whole disclosure is disqualified.
Exactly. If the third party's disclosure adds significant new material, or maybe describes a different variation or expands on your idea in a non-trivial way, then this exception, 102(b)(1), might not cover that new information. The examiner has to compare them closely.
Okay, so it's really focused on preventing someone from using a republication or a very close derivative of my own prior disclosure against me. It's not a blanket shield against anything related that comes out later.
Precisely. It keeps the focus on protecting the inventor from the direct consequences of their own initial disclosure and things that flow directly from that disclosure by others within that grace period context.
Got it. So pulling this together for our listener, for the learner trying to navigate this, what are the big takeaways?
I'd say two main things. First, know about that 1-year grace period for your own disclosures under 102(b), 1A. If you publish or present, you might still be okay if you file within a year.
Okay, point one, the personal grace period.
Second, understand the protection under 102(b)(1) against later third-party disclosures of the same subject matter you already disclosed. It stops others from blocking you using your own revealed information.
Point two, protection from echoes. Both are super valuable, especially if you've been active in sharing your work.
Absolutely. Knowing these rules, knowing you might need to file a declaration, knowing the importance of attribution and the same subject matter requirement, it can make the difference in overcoming a rejection.
Right. It really emphasizes careful timing and documentation around disclosures, doesn't it?
It does. While the grace period is helpful, the gold standard is still often to file before you disclose publicly. Don't treat the grace period as your primary plan A, maybe more like a safety net.
A very important safety net, though. Okay, this has been a great focused look at MPP Section 2153. It's a specific slice, but clearly a critical one within Chapter 2100.
Definitely. And for you listening, think about your own work. Have you disclosed anything? Are you planning to? Understanding these rules really helps you strategize how to protect your innovations effectively.
It empowers you, really. Okay, that wraps up this particular deep dive. We do need to give special thanks to Mike Shepard.
Yes, thanks to Mike Shepard, the creative director who organized and guided the development of this whole educational series.
And finally, the necessary disclaimer.
Right. Please remember, this summary was put together using AI tools like ChatGPT and Notebook LM. It might have errors or leave things out. It's for general information and education, definitely not legal advice.
Absolutely. For the official word, always go to the official MPEP itself or talk to a qualified instructor or a registered patent practitioner.
Couldn't agree more.
Thanks for joining us on the deep dive. We'll explore another section next time.